Hi, I'm attorney Gregory Dell, joined by attorney Rachel Alters. And Rachel, we're going to talk about why a disability insurance claimant would need a long-term disability lawyer for filing an appeal. And a lot of people who have come upon this video have found us because of the fact that they've just been denied their disability benefits, or they think they're about to be denied, and they know something about an appeal. But more often than not, it's someone who got a denial letter and it says you can file an appeal. So I want people to understand why they should have a lawyer, why they need a lawyer, because more often than not, the disability company is supposed to reach out to them. And they got this phone call, and the person on the other line who's with the insurance company goes, "I'm sorry your claim got denied, but you have an opportunity to appeal. Don't worry about it. Just go ahead and do an appeal." And I know they are not trained internally to tell them, go get a lawyer, make sure you have a lawyer help you with this. They kind of just push them to make it like, hey, if you don't like your meal, just ask for the manager. I'm sure the manager will come over and take care of this. But that is not the way it works at all in this world of disability benefits. So let's touch upon in this video about why someone should have a disability appeal lawyer to help them to file a strong appeal.
Sure. And oftentimes, and I'm actually surprised every time I hear it, but I'll get a call from claimants who say that the insurance carriers tell them not to get a lawyer during the appeal process, that they don't need it until they go to court. And I think this is a tactic for them to get claimants to file their own appeals because they know they won't be good enough to win the case in court. So if they say, oh, just write a letter, it's good enough, and they'll call me and say, well, I was told all I need to do is write a letter saying I disagree with their decision. And then after I can hire a lawyer, and I say, well, if this case is governed by ERISA, which most group policies all are, when you get to court, if you don't have every possible medical record, medical test, everything in that appeal, once that decision is made to deny the benefit again, the record is closed. You can't add anything else. So not only is it important to hire a lawyer to do your appeal, but it's important to hire a lawyer who is well-versed in ERISA, who specializes in ERISA, who knows how to answer these denial letters and what to put into these appeals, because you only get one shot. And after that shot, it's blown. You can't. So if after the appeal is filed, let's say, for example, the claimant files their own appeal, they write a letter, I disagree, or their doctor writes a letter and says, we disagree with their doctors. They submit it. The insurance carrier says, sorry, we're going to uphold our decision. We still think you're able to work. We cannot add anything once they call us. So we can't add, oh, you forgot to put in the surgical record, or, oh, you got approved for Social Security disability. We need to add that so the judge will see it. None of that goes in. So it's really important for them to have a lawyer in the beginning to handle the appeal process, to file the appeal, and especially a lawyer that knows what they're doing and is familiar with the risk.
Yeah, and that's an incredibly unique thing in this world of what people don't realize with these group provided policies that are governed by ERISA, which we've talked about, is that when you get denied, you are in an administrative process. You do not have the right to immediately sue, even though you may want to. So you have to file an appeal back to the same company that just denied you. But here you are as this claimant who's likely never done this before, do not have any idea as to what this even word ERISA means, which is the Employee Retirement Income Security Act, what those laws are, because it's one of the most complex areas of law of all areas of law that a lawyer could possibly practice. And it's also one of the most limited areas of law in terms of trying to find an attorney who actually does this day in, day out. You're unfortunately in a world of a complex type law that favors and was drafted in favor of insurance companies, because the whole point of ERISA was to create a law that would make it so that insurance companies and employers could offer affordable benefits for claimants. And they did basically achieve that goal, because if you look at the price for someone to buy $1,000 worth of long-term disability insurance or short-term disability insurance for a claimant, and you compare that to the price of the premium if you were to go buy an individual disability insurance from an agent on your own, it's probably 10 times more expensive to buy the individual policy than it is to get your benefits as a group benefit.
Right.
But with that, they said there's got to be a reason why it's 10 times more expensive for an individual policy versus an ERISA policy. And the reason for that is because you're not going to have as many rights, and we're going to make it where the cost, everyone thinks the cost of litigation is what drives up the cost of insurance. But we're going to make it where we try to keep these cases out of court. And even if they do go to court, we'll make it where it's even much harder for the claimant to win, that they won't want to go to court. So if we cut the cost of litigation, then we can offer insurance cheap. But what ended up happening at the end of the day is they created this process where you have to appeal. There's supposed to be rules to make it fair. Unfortunately, not all companies act fairly. More often than not, they don't. Claimants get denied. Then you go to court. The law is skewed towards the insurance company where you have this uphill battle. You don't start on this level playing field. We've done tons of videos where we talk about what to expect in an ERISA lawsuit. And then the claimant is stuck with the, with the situation of, what am I going to do with this appeal?
Right.
So the message I want to get across to people is when you're looking for first of all, don't do these appeals without a lawyer, because I often say, and we've said it 100 times, the lawyer you hire for your appeal could arguably be more important than the lawyer you hire for your lawsuit. Reason being, because if you don't have a super strong appeal, I don't care how good your lawyer is, it's like going to a gunfight when you could bring 20 guns with you, but you've only given the lawyer 2 guns. Don't set yourself up like that. Bring the entire arsenal with you, but you don't know what the arsenal is until you work with somebody who puts you in that position to have the arsenal. So what you do for someone in an appeal, talk about, what's your starting point strategy, the claim file, and kind of in a summary terms, what picture you're trying to paint so that you could win the appeal.
Right. So the first thing we do, obviously, is we read the denial letter, because in the denial letter, the insurance company is required to explain why they denied the claim and what you could add to the claim to help get your claim the denial overturned. So we look at the denial letter, we request the entire claim file, which is everything that is put into your file from the beginning of the inception of the claim. So the claim forms, any of the notes from the appeal special or the person handling the claim specialist, all your medical records that have been put into that file, and everything is already in there. So when the insurance carrier has your claim and they're looking to deny it, they usually send your medical records for a peer review, which is a paper review of all your medical records by a peer review specialist, whether it's depending on what disability you have, the type of doctor they hire is a neurologist or a cardiologist or just an internist, and they have them review your paper records to make a determination as to whether they believe you're disabled based on those records. And most of the time they will disagree with your doctors. And if your doctors say, well, we've been treating this patient for X amount of years, we don't believe they're capable of working, they find doctors who will say the opposite, because that's how this works. We read all of these reports, and then we determine from the peer review reports how we're going to go about fighting your case. So do we need to send you to a functional capacity evaluation, which is a 3-hour testing what your physical capabilities are? Do we need to send you for a neuropsychological evaluation if you have cognitive impairments? So if there was a peer review report that says, oh, we don't believe that there's cognitive issues, that this person doesn't have memory issues, we're going to send them for a testing that hopefully proves the opposite. Do we have to hire experts to review these reports and also to refute them? So we review the entire claim file, and then we know exactly what to look for. Since we've been doing this for years, we work with all of the insurance companies, so we know how they operate. So we know what to look for, but the claim file is where we start. And then we start, deciding what further testing, what doctors we need to have phone conferences with, we prepare attending physician statements. We cater them to each person's disability. We prepare them and we send them to the doctors, and we help them fill them out in the proper way to get the case overturned. So there's a lot of things that we do, and we know because we've been doing this for years, and we know exactly how these insurance companies operate, and we know who's reviewing the claim. So that's where we start normally.
It's a big challenge to get a super strong appeal put together. And I always tell all the claimants that 80% of the work of the appeal is gathering all the evidence, meaning many of the things you spoke about, support from your treating doctors. But what if it's not your treating doctor and you need to go to a new doctor? What if you have to go for these other exams that you made? What if we have to hire a consulting expert who reviews all the medical records and then gives, a comment about this? What if we have to hire an occupational expert because the insurance company got your occupation wrong and we disagree with the manner in which they say your job is performed, or they think you have the skills to do a particular job, but you can't do that job. So then we need to bring in a vocational expert. You have to think about every single thing right now during this appeal Because Rachel, how many appeals do you get? How many appeal denials do you review when someone calls you and you haven't done the appeal and you look at and say, wow, I would have done not one thing, two or three, but I would have done the following four things, and I don't think I'd be reading a denial letter right now.
Oh, absolutely. It happens all the time. And when the claimants call me and say, well, I did my own appeal, they've made this decision, then I review, what went into the appeal. I think, oh gosh, I wish you would have called me. There's nothing we can do. We can't turn back time. But had they called me and had me do the appeal, I mean, they probably wouldn't be in the position of needing to file the lawsuit. So hiring the attorney, and a very good attorney at that, is very important.
So
Yeah.
one of the biggest challenges I see, though, is the doctors want to be supportive of their patient and our client who has the appeal. But wanting and doing and knowing how to do it are two different things, meaning the doctors and claimants, they understand they're not the only patient of the doctor. But let's talk a minute. I want people to understand how the medical practice is. So this is the world of our medicine right now. If you have an internal medicine doctor, that doctor is probably seeing on average 40 to 50 patients a day. They're probably now getting paid between $25 to $50 per patient, where they used to get $150 to $200 per visit. They feel a lot of pressure to generate just the overhead to cover their staff, their office, the bills they used to make, because the Medicare and the insurance companies have all cut them down, even though all of our health insurance premiums have gone up. They're in their routine. It's what they do. Yes, they care about you, as the patient. However, they have electronic records as well. And when they do these records, a lot of things are checked off already. So they're treating the patient, not the chart, which is the electronic thing. And when the patient comes in, they have a relationship with the patient, and they know the patient, even though they see 500 patients a month. How are you feeling today? They look back at the notes. Oh, I see you have these 3 diagnoses, but how are you feeling today? I'm okay. Your okay is not the norm of what okay is for someone who's perfectly healthy. It means I'm not in excruciating pain today, or whatever. I'm functioning today. And the doctor just says, look, I want to make sure you're alive, you're living, you can do your activities of daily living, your blood work's okay, I'm trying to minimize your pain however I can, and go about your business. Doctor doesn't care or necessarily even know, unless the claimant tells them, hey, this is a long-term disability insurance claim. And by the way, doctor, every single thing you write in this record is going to be reviewed by this insurance company. And everything you don't write is going to become all of the evidence that I don't have. So that's where we come in as the disability lawyers and say, doc, you may not have had all of these other things in your records, but we have to create a custom attending physician statement. We have to basically take your deposition, your statement. We have to extract out of you all of the things that you know in your head have been going on with this claimant, and all of the restrictions and limitations that this claimant is saying she has. Do you support them? What objective evidence, what testing do you have to show this? What blood work, what exams of range of motion or anything else that you can see? Is there any atrophy? Is there any muscle strength testing, weakness? Anything that you could put in there, because unfortunately 8 out of 10 times, Rachel, they don't do it, because why do they need to? They know the patient's going to tell them what's going on. It's not going to kill them because they didn't write down, oh, the patient has 4 to 5 weakness in their hand. Patient has pain when they rotate past 40 degrees. Doctor's like, who cares? But the insurance company cares. And that's where they slaughter you. So the big thing we do is we do these custom attending physician statements. We then tie them in with trying to do some functional capacity testing to show through these tests. And even that can be subjective and gets argued, but you've got to pound the paper. And I always say you got to make them a mess on paper. And if you're not a mess on paper, the insurance is going to be like, we don't think you're so bad. We're going to deny you. And guess what? Good luck trying to get us reversed if you have to file a lawsuit. So the cases are super challenging, but there's tremendous, I just see so much opportunity when a client calls us to work on their claims, because if it's not their doctor, there's hundreds of other doctors who know how to work in this disability insurance world to document a claim. Just like they have doctors who know how to look for things that aren't there, there's doctors who know how to deal with documenting the evidence that supports a claimant to help prove to the insurance company that the person's disabled. Just a tremendous challenge. So What we always tell claimants is that they should reach out to you, any of the lawyers. We're happy to always provide you with a free consultation. As Rachel started earlier, it starts with the denial letter. That's the most important piece of information we need. We may ask you for your policy. Of course, after reviewing your denial letter, we're able to basically know within a reasonable degree of certainty if we're able to assist you, give you an opportunity to know what we think your chances are winning. Of course, we'll discuss with you fees or costs, and no matter where you live in the country, we're happy to help you.